There's a lot of discussion these days about greenhouse emissions, primarily carbon dioxide from power plants and manufacturing, from cars and trucks, planes and trains, and whether and how these relate to changes in our long-term climate. The government of California has decided to reduce local greenhouse emissions through a state law called AB 32. The state now has an emissions cap and trade program in place, and has also forced significant improvements in vehicle mileage. One of the other rules that the California Air Resources Board has imposed goes beyond emissions in the Golden State and seeks to control emissions all over the world. It's called the Low Carbon Fuel Standard, but don't let the name mislead you. It doesn't change the formulation of gasoline or diesel to reduce emissions. Instead, what it does is prohibits you from bringing fuel into California unless you've reduced emissions from making that fuel, wherever that happens, in Nebraska or Canada or Brazil or anywhere else in the world. Now, you might wonder how a state, even a big one like California, can regulate activity in other states. The answer under our Constitution is that it cannot. We have what our framers designed as a federal republic. Under this system, states are responsible to deal with matters within their own borders and leave each other alone. This was an important measure to prevent interstate trade conflicts that were a real backdrop to the ratification of our Constitution. Because of this, the United States Supreme Court has consistently rebuffed state efforts to impose rules on neighboring states in cases involving everything from milk to fresh produce, alcohol, coal, even solid waste going to landfills. So it seems pretty clear that California does not have the legal authority to regulate how fuel is produced in Nebraska or Canada. But when a large group of affected parties sued California over the low carbon fuel standard, the Ninth Circuit Court of Appeals refused to put a stop to it. Instead, that court applauded California for taking what it called legal and political responsibility for greenhouse gas emissions wherever they occurred. The plaintiffs have appealed the case to the United States Supreme Court, and Pacific Legal Foundation has filed a friend of the court brief encouraging the High Court to review this important case. States regulating each other's citizens is a basic violation of our constitutional system of federalism. In this case is particularly important because we have one state trying to micromanage the entire national fuel supply chain. We're pleased to be joined on the brief by Cato Institute, National Federation of Independent Business Legal Center, Reason Foundation, the California Manufacturers and Technology Association, and Energy and Environmental Legal Institute, all encouraging the court to take this very important case. If you want to learn more or get updates on this or any of the other cases that we're involved in at Pacific Legal Foundation, you can follow us on Facebook or on Twitter, or check out our website at www.pacificlegal.org. And thank you for watching.